Thank you. I'm sorry to interrupt. Go ahead, sir.
Thank you. My name is Peter Szymonik, and I live in Glastonbury, Connecticut. And I come here with a wide range of experiences. Probably most interesting and what may be a little bit unique is that I've worked in the legal industry itself for most of my career, although I'm not an attorney. I primarily specialize in the corporate world and the insurance world. And one of the things I'll kind of start off with is that I'm going to change my entire testimony because I like to kind of refer back to some of the testimony that Peter Nicita and Michael Nowacki brought to bear. One of the things that I struggle with, and I think a lot of people in this room struggle with, is no one here is stupid. I mean, we're all intelligent people, we all have children, we all have jobs. And from my own particular experience, one of the things that I find most frustrating about this entire system is that when you look at what these people are paid, when you look at the people that are engaged in your thing and their experiences, you expect the ultimate and highest level of ethical and professional behavior. Why wouldn't you not expect that? You people are experts, you know what's going on, you look at a court system, that's why we approach the courts. We've reached the point where we need to approach the court system for help because we've tried everything else. What I think a lot of people are dismayed by and where this destruction happens and the financial devastation is when what we experience is the exact opposite. Totally unethical behavior, totally unprofessional behavior, and no one to complain to. And the reason I want to go back to the example of Peter Nicita and Mike Nowacki is we talked about the relationship between the attorneys and the guardian ad litems. Now, picture this concept. In my case, we had an ex-parte situation in March of 2012. Engaged were a guardian ad litem and a therapist for my sons. I was given court-ordered authority to re-engage them with their previous therapists who'd known them most of their lives. So picture this scenario, Dr. Thayer, and picture this scenario, Dr. Horowitz. I'm now paying $4,500 to have you see my children on a regular basis. You know my children. You've seen my children for years. The guardian ad litem, who's new to the case, bills $26,000, sees my children once for all 2 hours, and in court blocks all testimony from the therapist from being entered or heard by the court. Blocks it. Even worse, the judge didn't even look at what we were trying to present. The judge took the GAL on her word and said, well, if the GAL is claiming privilege, we're not going to look at it. He never even looked at what we were trying to present. When one of the things we were trying to present is a list of appointments showing which parent brought the child. Why is this allowed to happen? The reason it's allowed to happen is because parents in our court system, as soon as you walk into the court system, and especially once a guardian ad litem is assigned, are automatically deemed to be invalid and incapable. We are treated as if we're zombies, that we have nothing to offer, nothing to contribute. And so one of the biggest structural problems that we have in our system is there should be 3 distinct separate entities involved. One are the attorneys, the Connecticut Bar Association. The other is the court system. The other is the mental health profession that supports us. And the biggest piece that people always forget and never include in the conversation are parents. Ever. Parents, taxpayers, citizens who are paying for these services. We do not get a return on our investment. And that's one of the biggest problems that we have. This is something that structurally needs to be changed. These people need to be brought into this discussion, and we are completely shut out of the discussion. That's not right.
Thank you. Are there any questions for Mr. Sesmak?
I'm sorry. Again, I keep forgetting to turn this on. Mr. Weismuller, go ahead.
Thanks. My understanding of your testimony is that you and the mom were both appearing in this proceeding, but they asked the guardian ad litem to make a recommendation as to privilege as opposed to asking the de facto guardians, the biological parents?
The guardian ad litem constantly throughout the hearings mentioned that she had privilege and blocked all testimony from the therapist from being entered, period.
Was there ever a judicial determination that the biological parents, the de facto guardians, should have their opinion weighted less on a medical decision than the guardian ad litems?
Never was.
For example, if your child, God forbid, had cancer treatment, would they be asking the guardian ad litem for that?
Well, and I think this is the problem from a legal perspective, because from a legal perspective, once a guardian is assigned to a case, this is no different than guardian elder abuse. Again, once a guardian is assigned to a case from a legal perspective, the parents are deemed invalid and incapable, both parents. And so what ends up happening is...
My understanding of the case law says that there's supposed to be a comparison made, and the case in question from the Supreme Court actually discusses a grandmother who was accused of, or actually established to be unfit at one point trying to act as the de facto guardian, and that is the case that people refer to commonly, and that there's not a case that says a biological parent who is not deemed to be neglectful or abusive should be overridden by a guardian ad litem. What case are you referring to?
Well, here's the difficulty, and this goes back to, again, something that was discussed before. One of the things that I struggle with is people that are in this industry have such a lack of appreciation of what actually is happening within the hallways of the family court every single day. So you can be absolutely correct. It's completely ignored and violated. And I make the comment, having worked in the legal industry, what I have seen happen in the family court would not be tolerated in any other practice of law in this country. Why is it tolerated in family law?
I just want you to know that I actually hear what you're saying regularly, that when the parents come in and they're talking about privilege, and in fact, I proctored the guardian ad litem training, and I was surprised to see that the training suggests that the guardian ad litem should grab onto that privilege and try to exercise it on behalf of the child. And I don't object to necessarily seeing that in the training. What I'm confused by is that I don't believe that is the law. I believe that's just the guardian ad litem being trained in the propriety of, in some circumstances, obviously trying to maintain the therapeutic relationship between the therapist and the child, which is very important, but there also may be overriding concerns that may relate to the best interest of the child that would make it appropriate for that testimony to come in.
And as an extension of that, here's the biggest problem. Whose role is it and whose job is that to determine that? The judge. Instead, what the judges do is outsource the judicial authority to the guardian ad litem and automatically order or do whatever the guardian ad litem wants. That's absolutely wrong.
Technically, I believe that it's the judge's obligation to consider the objections and then make a ruling as to who holds that authority, and my understanding is it would be the de facto parent and not the judge.
And it doesn't happen, unfortunately.
Okay. Oh, no, I'd really like to see the case law, because I would like to see that.
Incorrect as a matter of Connecticut law.
Okay, we reviewed all of the case law here. Yeah. Do we have that?
There are other cases that have not been provided to the task force, and it's pretty clearly established by case law. Yes.
I stand corrected. I guess there's a case that says the GAL overrides the biological parents. That's very interesting.
Multiple.
Well, and then as an extension of that, again, put yourself in the seat of a parent. You've now paid the therapist $4,500. You've now paid the guardian ad litem $26,000, and critical evidence related to the best interests of your child is being withheld from the judge in the court. You're paying to have information withheld from the court.
Well, typically, if I may just jump in, typically one parent is in favor of the child's therapist testifying, and the other one is not. So to some extent, they are canceling each other out, and that's where the guardian ad litem is.
And parents are paying for that.
But it doesn't make a difference if one parent has the sole.
This is not a committee. We're not going to engage in a lengthy discourse with anyone other than the speaker. But in any event, are there any other questions for Mr. Szymonik?
Well, I just have a comment. I mean, one of the things you have to look at there, too, is your child's going to therapy and establishes a bond with their therapist and not necessarily wants what they've said to their therapist to be put in public. So if you're thinking about your child's best interest, that's also something to think about. You just testified that all you wanted to say was who brought the child to the doctor and who didn't. You could have, that I don't believe is privileged information.
Absolutely.
I believe that you could have said on the stand, your lawyer could have elicited testimony from you what days you took your child to the doctor.
We were not even allowed to go to, as soon as we mentioned the therapist, all conversation was cut off by the judge, period. We did that. It was cut off by the judge, who used to be a guardian ad litem, by the way.
Dr. Horwitz.
This may very well be embedded in your written testimony, but I just wondered if you had any specific recommendations for this task force.
I absolutely do. I submitted information to this task force that has task force recommendations from 8 other states who have gone through this exact same process, schools of law. The New York State Bar Association conducted their own independent study and presented it to the New York State Bar. The state of Maine passed sweeping guardian ad litem reform over the summer. Here's some specific recommendations. Number 1, it is absolutely unconscionable that the state of Connecticut imposes guardian ad litems on parents, and nowhere does the state keep track of what these people are paid. Nowhere does the state keep track of how much time these people actually spend with the children. This is now law in the state of Maine. In the state of Maine, the guardian ad litem, what they are paid is now reported by the state and is publicly accessible. The guardian ad litem has to report how much time they actually spend with the children, so they're not spending 95% of the time chit-chatting with the attorneys and not meeting with the child. In the state of Maine right now, before a guardian ad litem is assigned, there is a meeting that involves the judge, both attorneys, and the parties to establish what the guardian ad litem is and is not supposed to do, and all the parties sign off that they can actually afford the guardian ad litem. The guardian ad litems can be engaged on flat rates. And here's the other question. If we basically have a scenario where guardian ad litems are supposed to evaluate children according to 16 set criteria, why are they paid by the hour? Every single child is the same. It doesn't matter if they live in Litchfield. It doesn't matter if they live in New London. It doesn't matter if they're a son of a millionaire. It doesn't matter if they're a son of someone on welfare. How is the work different? And what explains that Mr. Nowacki's bill is $252,000, mine is $49,000, and someone else's is $15,000, and the law center can do it for $20 a day? That makes no sense.
Are there any other questions? Representative Gonzalez. All right. Please don't make me keep asking you to stop doing that. Please stop with the cheerleading. We have 75 people we need to get through. We do not need to waste time with cheerleading in between speakers or after statements.
Representative Gonzalez, your question?
Yeah, good question. Do you have any guardians ad litem statistics?
I do. Or can you ask the question?
Yeah, do you have any numbers, any statistics about guardians ad litem?
Yeah, I understand.
I'm sorry, I didn't understand it either.
Statistics.
plenty.
Do you have any? You have?
Essentially, I have a website that I created called GALreform.com that over 500 parents have signed. I've reached out to those parents and asked them for their guardian ad litem bills because, again, I'm an expert in legal billing, to examine what these guardian ad litems are paying for, what percentage of time they actually spend with the children, what the average costs are. As a random sample, I got feedback and responses from probably about 46 parents, and also including family law attorneys and guardian ad litem themselves, I'll add. What was shocking to me is when I crunched the numbers, the average person that wrote back said their average guardian ad litem bill was $46,000. On average, these guardian ad litems were spending 1 hour a year with the children they were assigned to represent. 1 hour. Even worse, I asked these people, just give me a letter grade, okay, and regardless of what the outcome was, what good of a job do you think the guardian, they ask appropriate questions, whether you're upset with them or angry with them, almost universally, every single guardian ad litem got a grade of F. Now, having said that, there were guardian ad litems that got A's and B's, because why? They actually spent 100% of their time with the child, talking to their children, talking to educators, talking to their therapists, talking to their family members, visiting their homes. That's what guardian ad litems are supposed to do. Attorney guardian ad litems almost never do that.
Can you provide us
The information?
that information?
The raw information I'm absolutely happy to provide, yes. The individual names I will not because, again, I don't
Yeah.
want to expose people.
Yeah, thank you.
And Mr. Szymonik, I'll ask you if you would forward that to the LDCC at cga.ct.gov.
Quick correction, you accidentally said that it was galreform.com,
.org,
but that's .org.
yes.
Thank you. Okay, thank you very much. And the next person on our list